the Mid-Atlantic Logger Training monthly webinar series. Today's topic is truck accidents and other casualty claims. How do we win? This presentation will help you understand the precarious environment in which commercial vehicle operators exist and the things you can do to best anticipate and defend against potential claims. But before we get started, we do have a few housekeeping items. I'm Karen Snape, and I'll be your host for today's session. First, I want to thank you for being here and let you know that the session is being recorded. The recording will be available as on-demand training later through West Virginia's continuing education website. Right now, all of your cameras and microphones are off, so nobody can see you or hear you, and you cannot change those settings by yourself. But we do have a way for you to participate and hopefully ask questions. In order to communicate with us and with our speaker tonight, you have these three options. All of these buttons should be at the bottom of your screen. You may need to move your mouse around a little bit, or if you're on a tablet or a phone, you may need to tap in order to see those options. But the Q&A button, which looks like two little cartoon talking bubbles, that can be used to enter questions, which our speaker can answer for you, either verbally or in writing. And then if you've got other comments to make, you can put those in the chat, which looks like a single cartoon talking bubble. And if you would prefer to ask your question out loud, you can raise your hand with that icon that looks like a hand, and I can enable your microphone then for you to ask a question verbally. Tonight's session is worth 1 continuing education credit in whatever logger training system you are part of. So that's the Ohio Master Logger, the West Virginia Certified Logger, the Virginia Sharp Logger, or the Maryland Delaware Master Logger. Certificates of completion will be emailed to you using the email that you used to register for the webinar. And then the participant list will also be forwarded to your state's coordinator. So for Virginia, that's me. It's probably Agnes, Brad, or Ben. So you don't need to send your certificate to your credit coordinator. They'll have a roster, but you should save your certificate just in case anything goes wrong so that you have that record. It might take a couple weeks for your credits to show up in however it is that you check your credits for your system. But if it takes longer than a few weeks, you probably want to reach out to your credit coordinator with that copy of your certificate. So this is where we had our schedule for the rest of the series, but tonight is the last session in the 2021 series. We are working on the 2022 series. We're going to keep on doing this. And so hopefully y'all can continue to attend and maybe even encourage friends and colleagues to attend. So does anybody have any questions about any of that housekeeping stuff before we begin today's session? I'll give you a few minutes. Remember, you can use the 2 chat bubble, the 1 chat bubble, or the raise hand if you have any questions. I see we're up to 14 participants, so that's very nice. I think we'll have a good session tonight. If there are no questions, then I'll introduce tonight's speaker, Stephen Setliff. Mr. Setliff represents clients in complex litigation at the trial and appellate level in state and federal courts across the United States. His multifaceted trial practice includes representation of clients across a broad array of industries with a focus on transportation companies, including trucking companies and railroads, and claims of traumatic injury by employees and non-employees. His trucking practice includes the representation of trucking companies, their insurers, and their drivers in a wide variety of claims, including catastrophic personal injury, property damage, and toxic cleanup. He also handles workers' compensation claims, negotiating, drafting, and enforcement of commercial agreements, including brokerage and independent contractor agreements, traffic citations, including felony charges, and employment claims under the Surface Transportation Assistance Act. His practice covers the gamut of trucking litigation, from first scene accident investigation to effectively and efficiently trying cases to verdict. So with that, I'm going to stop my screen share so that Stephen can do his. And whenever you're ready, you can start your presentation.
Just 1 second, right here.
Okay.
Yep.
Karen, thank you very much. I think we got it figured out. It's always a little bit of a challenge for me with the technology. I'm more of a blackboard and marker guy than I am a technology guy. But I appreciate everyone being with us tonight, and the folks who ultimately will hear this by way of video, and I will do my best to continue to be planted in this chair. Those of you who have been with me before know that I like to pace and walk and use my hands and talk. So I'm hopeful that it is as entertaining to you tonight on video with me sitting as it is as I'm otherwise walking around. The topic of the presentation tonight is stated enemies at the gates. And that's really a way of me conveying to folks out there what is going on relative to the industry in which we operate. That is a commercial industry where we are moving things over highways and roads and otherwise interacting with the general public. It has turned out to be that is an environment in which the folks who actually do the moving, that is the commercial operators, have increasingly become targets and find themselves battling against the bad guys who want to take the things that we have and want to take our businesses and take the money from our businesses by way of claims that they otherwise made. So it is very much indeed enemies at the gates. And in many instances, given the environment in which we currently operate, the enemies are actually inside the gates now. We're fighting a war, to be honest with you, that is being waged on multiple levels. We all operate and live in environments where advertising such as this is fairly prevalent, both on billboards and in magazines, and as a matter of fact, on television. If you ever find yourself sitting at home one afternoon recovering from a bad cough or cold or flu and turn the television on, you will find a litany of lawyers advertising themselves as truck accident injury lawyers. As a matter of fact, wherever you live, I would encourage you just to Google that expression, truck accident injury lawyers, to see how many folks come up. You can do it here in Richmond, and literally hundreds and hundreds of lawyers will come up, of folks who hold themselves out as being expert in suing people, commercial vehicle operators, whether logging trucks, commercial trucks, just box trucks, tank trucks, any kind of trucks, dump trucks, in an effort to get at the things that we own and our businesses. You also will see things like you see on the screen here on the left, where folks take articles out or take advertisements out in magazines in an effort to convey not only their expertise in suing commercial operators, but also all of this stuff is an effort, whether it's television advertising, billboard advertising, magazine advertising, is an effort to start to color and to persuade potential jurors, that is the general public, that trucks and the vehicles that we operate are in fact dangerous, and that we as operators of those vehicles are dangerous and we're somebody to be afraid of. And in fact, not only somebody to be afraid of, but somebody to be punished. You will hear
Stephen?
a lot. Yes?
Stephen, real quick, we can't see your PowerPoint, your screen share.
You cannot.
No, I'm sorry. Do you want to click on the green share screen button?
Hold on 1 second.
Yeah, I'm sorry. Is
Okay,
your assistant still there, your admin?
Yeah, hold on just 1 second, Karen.
Yeah, I'm so sorry.
No worries. Katie, here, please.
So Stephen's got an admin that's going to help him get that
It's not
screen
showing.
share up.
Not showing.
Did you just hit share screen?
It's not.
So it's a green button on the bottom with an up arrow.
Get rid of it. If you got to get rid of this, just hit end show. Go to this. End show. Minimize that. Come up here. Hit share screen. And now go to your presentation. Double click it. Can you see it now, Karen?
I can see it now. Yes, thank you.
From the beginning. Okay.
Okay, so let me slide a couple of slides in. Thank you, Karen.
Yeah.
I would have just kept right on rolling.
Yeah.
So we live in an environment where the things that we see, whether it's by way of advertising, television advertising, magazine advertising, any other kind of advertising that's directed to the general public, as well as the attack that's made against us by the plaintiff's lawyers, is something that's called the Reptile Theory. And without going into it in a great deal of detail, just suffice it to say it is a theory that's used by claimants' lawyers, television lawyers, the bad guys, to appeal to a jury to try to convince a jury that we are in fact dangerous and that we are to be punished and that is eliminated. The complexity of it really is not important other than to understand that the way the bad guys do this is by coming after us and painting us as something that's dangerous, something that has some understanding of what we should be doing to operate safely, but that we don't operate safely, that we ignore the things that we should be doing to operate safely and in fact create a danger to the folks in the general population. And you know what? It's working. It's working on a very wide scale across the United States. It's working so well that, as a matter of fact, in a case that was recently tried in Florida, a Florida jury returned a $1 billion verdict against a commercial vehicle operator down there. That's 1 billion, not millions, not tens of millions or hundreds of millions, but $1 billion verdict. It happened in Nassau County, Florida, where an 18-year-old college student was killed by a driver who was operating his vehicle while on his cell phone over legal hours without a CDL. Terrible, terrible facts, horrible, horrible facts for the trucking company. But the jury was convinced that based upon the danger that the trucking company posed to not only the folks that were injured, but the community at large, that the way to deal with it was to return a verdict of over $100 million to the decedent's parents and $900 million to the decedent's parents in punitive damages. That's simply remarkable. And it tells me the extent to which the theory and the attack that's being made upon us by the plaintiff's folks is in fact working. You'll note that the case was tried for 5 days. The jury took only 4 hours to return the $1 billion verdict. The game plan that's followed by the bad guys in all of these cases is the same game plan that's followed each and every single time that I see one of these cases. The whole idea is to make us, that is our logging companies, look like we are a danger to the community, to try to demonstrate or try to argue that whatever happened in the 2 to 3 seconds before an accident actually occurred was something that was entirely preventable if reasonable steps had been taken, and that it was not an act of God, and that there is something about this company, your company, that makes you dangerous, that you had rules that you either knew about and violated or you never bothered to promulgate in the first place. That's what they do each and every time. I've been seeing it now for about 20 years. It's the same game plan over and over again. So if you know that, if you know going in that if in the event that one of your drivers gets involved in an accident, somebody gets hurt and there's going to be a claim, and you know the attack that's going to be made on you and how it's otherwise going to be made, what can you do to try to position yourself to deal with that, to be in the best position that you can possibly be in to deal with a potential claim and or a lawsuit that comes as a result of an accident? Well, there are some things that you can do before the accident. There's some things that you can do at the time of the accident, and there are some things that you can do after an accident has otherwise occurred. And I'm going to talk about each of those in turn and suggest to you that you think seriously about adopting some of the things that I'm going to tell you. And I'm going to tell you, you're going to hear me say over and over again relative to the things that you ought to be doing, is that you need to take a step back and look at your company and look at the way that you were doing things relative to understanding how a claim ultimately is going to be made against you. And as you assess each aspect of your operations, you need to think to yourself, how is that going to look to a jury? If a jury were to see how we conducted our business, what would they think about it? Would they think that we're doing things the right way, or would they think that we're cutting corners and taking shortcuts and doing things that make the operation of our business most dangerous? So what happens after there's been a claim? So there's been an accident and somebody gets hurt. Within minutes and probably hours, and certainly within days, anybody that's been hurt as a result of a collision with a commercial motor vehicle is probably going to contact or be contacted by one of our friends, the TV lawyers. And those guys are going to tell them that they'll sign them up and that they'll get them lots and lots of money in connection with the claim against the company. And these are the things that they otherwise need to do. And so then they're going to file a lawsuit against us somewhere. They'll make a claim as a preliminary matter, and it may be that the insurance company settles it and it never gets to a lawsuit, but more often than not, if an accident happens and a claim's made, it's going to end up being a lawsuit. And if that lawsuit is filed, you're going to see a couple of things that are always claimed in that lawsuit. You're going to get a claim that first, whatever your driver did was wrong. And at the time of the accident, whatever he was doing was the wrong thing to do. And as a result of having done the wrong thing, he caused the happening of the accident. The other things that you're going to see in the lawsuit are going to be claims that The driver that you had employed should have never been hired, that you were negligent in hiring the driver that you put behind the wheel, that the driver, if he was okay to hire, was certainly negligent for you to keep him on the payroll. There were things that happened after you hired him that should have caused you to let him go. There are also going to be allegations that your inspection, repair, and maintenance programs are inadequate, that they don't compare favorably to the other folks in the industry, and or that your training program, that is the programs that you use to onboard and to train your employees, are in fact deficient when compared to other companies in the industry. So if you know all of that, if you know those are the kind of claims that they're going to make, then I'm going to tell you some things that you ought to think about doing to try to get ahead of each of those type of claims, to get yourself as well positioned as you possibly can. And in 36 years of handling these kinds of cases, I can tell you that the one thing that comes up over and over again in all of these cases is training. What kind of training are you doing? What kind of training are you doing when you onboard brand new employees? What kind of continuous training are you engaged in after you have onboarded employees? Whatever you did when you hired that driver 20 years ago or 15 years ago, the conditions in the workplace, conditions in the world have changed since that time. Have you done things to keep that driver up to date with not only the type of equipment he's operating, but with changes in the rules of the road that may be prevalent in the state where you otherwise are operating, or changes just in the environment in general? So training, it's a big deal. Again, use it as a template. Think about what I'm saying. If I've got to stand up in a court somewhere in Baltimore, Maryland, in Charleston, West Virginia, in any of the places where I otherwise practice law, here in Virginia somewhere, and hold up a copy of your training program. And I guess that begs the first question, do you have a training program? Because you better, because if you don't have a training program, that feeds very neatly and cleanly into the narrative that I told you that they want to convey earlier. That is that you're dangerous and that you're somebody to be punished and somebody to be put out of business. So not only having a training program, but looking at the constituent parts of your training program is important. How did you decide to include whatever you included in your program? Are you including things that address the kind of problems that you're having? If you have drivers who are having issues with following too closely or passing and being passed or going over railroad crossings or dealing with turns and curves, are you incorporating those things into your training program? And if somebody sat you down and asked during the course of a deposition, why is it that you included certain things in your training program and why were other things not included? Would you be able to answer those questions? Those are very, very important things for you to focus on. Making sure that we have an adequate program in place to onboard drivers, so we can say that we familiarize them with how the company operates. We familiarize them with the equipment they're going to be using. We familiarize them with the routes that they're going to be running. All those things are important to help us get ahead of the kind of claims that the bad guys make. And I'm also going to tell you, in addition to the onboard training, the ongoing training is a big deal. Participating in sessions like this, participating in safety meetings that you run from the business locations or out in the field, doing things to continue the training are all things that juries are going to expect a responsible business to be doing in 2021 and beyond. So make sure that you're staying on top of that. You heard me say just a moment ago, in addition to training, the other place that you're going to get picked at relative to the defense of a lawsuit is what your hiring protocols are. And I know we are living in a time where it's very difficult to find operators, particularly operators of commercial equipment. We've got a nationwide shortage of truck drivers that I don't see ending anytime soon. And as a matter of fact, I see probably getting worse for any number of reasons. Having said that, you need to be able to defend whatever your hiring protocols are. And the first step of that is to be able to articulate what your hiring protocols are. If I went around right now and asked everybody on this call or everybody who's listened to a simple question, could you answer this question? What is your hiring protocol? What do you look at when you are making decisions about hiring somebody, particularly somebody who's going to operate a commercial vehicle? What do you look at? What do you look at relative to their driving record, their accident record, their citation record, and how much are you willing to tolerate before you otherwise put them behind the wheel of a vehicle that you are operating? You need an articulable and you need a defensible hiring protocol, something that you can say, this is what we do, this is why we do it. Because otherwise you're going to get a claim in the lawsuit that whoever was operating the vehicle should have never been there in the first place. You never should have hired them. You'd be surprised, and I, again, as somebody who defends operators of commercial motor vehicles, I see lots and lots of folks who hire people who have substantial criminal records, people who have substantial history of moving violations. Some of that can be okay if you've got an articulable protocol for what it is that you're hiring and why you are hiring them. Just be aware, every time you put somebody behind the wheel of a commercial motor vehicle that has any kind of criminal history, any kind of moving violation history, any kind of prior accident history, that's something that's not only liable to, but almost guaranteed to come up in the event that they're in an accident and there's a subsequent civil suit. So again, the magic question here is, what is our protocol and why? In the world of a defense attorney, the best people to hire are the experienced drivers who've driven millions of miles without any incident. But they are like unicorns. They're hard to find. Being able to articulate what your standard is and why it's your standard is a very, very important thing. You would think in the industry in which we live in, particularly the operating of commercial motor vehicles being as heavily regulated by the federal government as it is, that if you comply with the FMCSA regulations for things that you have to do relative to hiring somebody, that is, our drivers have to be 21 years old, they have to be able to read and speak English, they have to be able to safely operate the vehicle, they got to be physically qualified, they got to have a CDL, they got to pass a successful road test, all the things that our drivers have to do. You would think that if you did those things and you had a driver who passed those prerequisites, that you've done all you needed to do. You would think wrong, however. Those are the minimum standards that you have to be able to demonstrate that your employees meet. Those are not the standards that will insulate you from getting sued on a claim for negligent hiring. So again, make sure that you have an articulable standard that does at least these things and that you can defend why you hired anybody that you hire. I tell people when you are going through the hiring process to make sure that you are doing things that are not only simple, but things that are that give you the fullest ability to understand who it is that you're putting on your payroll to the fullest extent of the law. And I always tell individuals or companies that I'm dealing with, there should be an expert who's in charge of handling your hiring. Somebody who knows how to conduct interviews, somebody who is making sure that references are followed up on, somebody who's making sure that there are background checks that are done, somebody who is investigating the circumstances of previous instances. All those things are important. And here's why. Not only do you want to do it so that you have a barrier in place to filter out the people that you should not be hiring on the front end, but I can promise you, if you get involved in a lawsuit and you've actually put somebody on or hired somebody that you probably shouldn't have hired, all these things will be questions that will be asked during a deposition. Did you interview them? Did you, in fact, follow up with references? Did you check social media? Did you look for gaps in employment? What did you do about convictions? What did you do to investigate previous incidents? Those are all things that you need to make sure that you're checking the box and otherwise doing. In addition to having people claim that you were negligent in whoever you hired, you're also going to have claims in these lawsuits that we were negligent for the employees that we retained. There's a difference. You can be completely justified in hiring somebody, but there could be an allegation in one of these claims that even if that person was appropriately hired, that the company in the exercise of reasonable care should not have retained that employee, that something happened after the time the employee was hired, which should have caused you as a reasonable employer to say, you know what, we need to take this guy, at least take him out from behind the wheel and maybe get rid of him as an employee. Again, it's the same question. Ask yourself as you listen to this and you think about this, what is the standard that we embrace relative to employee retention? If we've got a commercial vehicle operator out there and they get involved in an accident, is that automatic termination? If they get involved in a chargeable accident, is it automatic termination if they get a ticket, a reckless driving ticket or a speeding ticket? What is the automatic trigger, or what is the trigger for you to take an operator from behind the wheel of a commercial vehicle? You need to be able to articulate that, and you need to be able to articulate why that you do what it is that you do. Because again, I promise you, if you get involved in an accident, there are injuries and there's a claim and a subsequent lawsuit, and you're seated as a deposition, as almost always safety directors are, as almost always the owners of the company are, you'll be asked these questions. Well, why did you keep them on the payroll? Why did you continue to let them operate a commercial vehicle? And the argument would be that you should not have let them continue to operate a commercial vehicle because you were on on notice or had some indication that whoever you were letting operate that vehicle was in fact dangerous. And had you simply taken them from behind the wheel, the accident that is the subject of the claim would not have occurred. You would think that doing the routine stuff, the things that are required by the federal regulations, would be enough to inoculate you from claims of negligent retention. That is, pulling the review of driving record, or looking at the violations for each driver, or having the appropriate medical and physical examinations, or maintaining DQ files. But it's not. Just as I told you earlier, relative to hiring, those are qualifications relative to retention that establish the floor, the minimum of what you have to do. You have to do this and be able to articulate whatever standards you otherwise embrace relative to retention. And again, it's the same kind of techniques, making sure that you employed for purposes of hiring, making sure that you're doing the same type of things relative to retention. And above all, it's being consistent with who you hire, consistent with who you retain, and doing the things that you need to do to cull the herd when you need to get the folks that are not suitable for the operating of a commercial vehicle out from behind the wheel. Failing to do that literally causes you to risk your company each and every day that they operate a vehicle. One of the big things I always add here, and it's kind of an interface between the hiring, retention, as well as the training. It's the other reason why training is so important. If you're going to retain employees, particularly those employees who have some kind of minor slip up, you need to be able to demonstrate if the employees had some kind of minor slip up, that you have done the things that you need to do to address that, to coach them, to counsel them on how to address whatever the issue is so that the same problem is not otherwise repeated. So again, training kind of bleeds over into the hiring and retention process. I will tell you that the statistics pretty much uniformly bear this out, that folks who do the best job on the screening, on hiring, typically have the lowest incident of being sued and have the lowest incident of serious incident. And the folks who do the most training likewise fall in that category. So I would encourage you to do that. The other thing that you need to think about now is what's your CSA score? I won't go into a whole lot of who, what, and where about what a CSA score is. Everybody pretty much knows what the CSA scores are, and there's great argument about whether or not the bad guys will have access to your score. There are a lot of folks that think that those things are private. But believe me when I tell you, they will figure out a way to get your CSA score. If you don't know what your CSA score is, find out and figure out how you can aggressively and actively monitor your CSA score. And for goodness sakes, whatever you do, make sure that you are contesting each and every violation that even has the potential to adversely affect your CSA score. A very poor CSA score that's rolled out in front of a jury is in fact the kiss of death. It rationalizes the entirety of their argument that you're a bad guy and that you're dangerous. So I tell companies that I represent that, yeah, it might cost $250 or $300 to hire a lawyer to go contest some charge for improper lane change, for following too closely, for scale violations, for hours of service violations, for any kind of violations. But contest each and every one of them. There are remarkable things that you can do through the contesting system, which will allow you to sometimes beat those charges and keep your score in good shape. You really need to make that a focus of what it is that you do. And that, in my book, is really a great deal of attention to detail. I also tell folks that in 2021, you need to make sure that you've got an employee handbook. If it's just you working by yourself, you probably don't need one. When you add that second employee, though, you need an employee handbook. Why? Well, an employee handbook is one of those things in the world where we operate now is an expectation of jurors that we are going to have one, that we're going to have a handbook that articulates for our employees how we expect them to operate and for the things that we will tolerate and will not tolerate and the things that we expect them to do. I run a law firm. I got 30 people that work for me. I don't have any commercial vehicles on the street, but I've got an employee handbook, and I would encourage you to make sure that you do. Your employee handbook, if crafted correctly, should be the interface of three separate things. It should be one that has input from whoever is in charge of how you operate, that is the way that you do things. You should have interface input from whoever runs your safety program that's responsible for safety at your place, and you need to make sure that you've had legal counsel on it to make sure that the things that are in your employee handbook are consistent with what the law actually says. And not only do you need to develop a comprehensive employee handbook, you need to check that employee handbook. I keep a calendar reminder on my calendar and would encourage you to do so of once every 6 months, pulling up your employee handbook at lunch, sitting down to make sure that it still accurately reflects the way that you do things. The only thing worse than not having an employee handbook is having an employee handbook that suggests that you do things a certain way when in fact that's not how you do it. That looks really bad in front of a jury. So you want a handbook that conveys how you do it. It has the operations piece, has a safety piece, has a legal piece, all baked into it, and that same handbook is reviewed on about an every 6-month basis to make sure that it continues to reflect how you're doing things. Let me also say that in addition to having one, you want to make sure that every single employee that comes to work for you is issued a copy of that handbook and acknowledges either on paper in writing or by some kind of computer entry that they've not only received the handbook, but they have read it and they understand the contents. Again, that's important. We're going to want to be able to say to a jury in the event that you have an accident from which there's a claim and a subsequent lawsuit that our employees were told what it is that they were supposed to do. It may not help us with respect to whether or not they had an improper lane change, but it will help us a great deal when it comes to trying to convince a jury that the company itself should not be punished for what it is that happened. Because again, remember, the first thing that my job is in the defense of any of these type of claims is to convey to a jury that we are good guys. We're not somebody to be feared. We're not somebody that's dangerous, but that we're good guys and we embrace standard employment and operating procedures consistent with what's otherwise prevalent in the industry, and that is we do things the right way. An employee handbook is a big piece of doing that. There are a lot of pieces that should go in there, and I'm happy to talk to anybody who would like to talk about that. But things like what you no harassment policies, the kind of things that you will and will not tolerate during working hours, what your working hours are, what your expectations are for employees. There are a ton of things that otherwise go into it that I would encourage you to make sure that you otherwise include. Some best management practices, many of which we otherwise know. I would tell you these are the kind of things that you ought to be monitoring and be implementing. I realize there's always a cost component associated with a lot of this, and gosh knows that if you go to some of the trade shows that I go to, the technology today is remarkable in terms of crash avoidance and some of that kind of thing, but it's not always cost effective to either retrofit a fleet or to buy new equipment with those things. Having said that, you need to understand that what's developing in the industry is an expectation that operators of commercial motor vehicles are going to have at least some crash avoidance systems, crash mitigation systems, cameras, things like that on their vehicles, even if it's sophisticated GPS devices. And we need to have some of that to the extent that it's possible to be able to demonstrate that we're operating consistent with what's otherwise prevalent in the industry. So doing things that help monitor how your drivers are behaving, maybe putting governors on the trucks, maybe making sure that they're issued to the extent that they're going to be out traveling different places, that they have a company issued or approved GPS devices, that there's some type of device used to monitor what it is they're doing, some type of telemetrics, so that we can say that we were doing things proactively to monitor the behavior of our drivers. I would encourage that to the greatest extent that it's consistent with your budget. It always pays off. The other thing I tell folks is we have a tendency, no matter what business we're operating, myself included, to get really close to our business and to sometimes lose track of how we compare to people that are operating elsewhere in the industry. So I encourage folks, very vigorously encourage folks, at least once every other year to bring somebody in, to bring a consultant in, bring your favorite lawyer in, bring somebody from your insurance company in to look at how it is that you are doing things. What does your inspection, repair, and maintenance program look like? What do your hiring retention programs look like? What's your employee handbook look like? Are you doing the things that are comparable to other similarly sized businesses in the area, where you otherwise operate? Because that's the standard of care to which you are going to be held. This audit, which is what I call it, is typically a low-cost way to have another set of eyes come in and tell you what's this going to look like if we have to show up in court in some of the places where you otherwise are operating your vehicles? Really, really important. It's a tune-up. Think about it as an annual physical that will help keep you out of trouble. Talked about another thing that you can think about doing. Doesn't work for everybody, but something that I suggest to folks who have suitable assets where this kind of makes sense for them. And that is what I call the silo approach. If you operate your business, have all your equipment, all your assets, your business, everything under one corporate umbrella, then that corporate umbrella is what's going to be subject to having being used to satisfy any judgment once you exceed the limits of your insurance coverage in the event that there is a claim with injuries resulting in a lawsuit where a verdict is returned against you. The way it otherwise works is there's a claim, there are injuries, there's a lawsuit, and if a verdict comes back and it exceeds the amount of your insurance, then the claimant's attorney, the TV lawyer, if you will look to your actual business assets for purposes satisfying whether the extra may be left over for your judgment. That's the land that you own. That's the business that you own. That's the machinery that you use, including your trucks, the machinery that you use out in the forest. Those are all things that can be used to satisfy a judgment. So think about and talk to your lawyer, talk to your accountant to see if it makes sense for you. But advice that we give to a lot of folks is think about separating your businesses into different silos, if you will, so that one company owns the land, one company actually runs the business, one company actually owns the assets of the business. It's a way to prevent your losing the entirety of everything that you own in the event that something bad happened. Again, not for everybody, but it's something that works in a lot of different circumstances. I would also tell you to think about the image that you portray to the general public as you sit here today. If you Google yourself or you Google your company, what do you get? And the reason I say that to you is because in 36 years of trying cases, I have heard almost without exception the judge give a charge to the jury that sounds something like this. Ladies and gentlemen, jury, you're supposed to consider that only the information and the evidence that you hear in this courtroom for purpose of rendering whatever verdict that you are to return. You're not to consult with any outside resources, including no internet, no phone, no TV, nothing else. Every juror hears that. The jurors in the case that we all just saw, the Powell Rittenhouse case, they heard the same things. But more often than not, it has been my experience that jurors hear that, and then as soon as they walk out of the courtroom, they pick up their phone, they go to their laptop, they go to wherever, and they Google, and they see what it is that it says about you and your company. So you need to be aware of what your internet presence is. First, do you have one? If it's more than 2 or 3 people working in your company, you probably ought to have an internet presence. You don't need to spend $100,000 on a website or even $50,000, $20,000, whatever on a website. You just need something that looks like it portrays a competent corporate citizen that's trying to do the best things that it can do in the community. And it's here that I would tell you to make sure that you're doing a couple of different things. I tell everybody that I represent, you should enter every single safety contest, every public service contest, any kind of contest where you can be favorably recognized. You don't have to be recognized as the safest logger in Delaware or win year after year the safest logging company in the Commonwealth of Virginia or the state of Maryland, anywhere else. But any kind of recognition that comes from our respective logging associations for anything should be something that you are entering, that you're applying for, and that if you win it, that you put on your website. If you get any type of community recognition for anything, put it on your website. Make it something that if somebody, in fact, does go to look at you and see what you're doing and to see what kind of company that you have, they're going to see positive things about you. They're going to see that you've been recognized by the State Logging Association for this, or you've been recognized by the city of Harrisburg for this, or you've been recognized by Baltimore County for that. Those are all things that are easy to do. The other thing I would tell you to do is to write a couple of checks to some non-controversial fundraising type things. I certainly don't go out and put on your website that you are a proud supporter of one political party or the other. That's calculated to cause dissent among some of the people that may look at your website. But certainly giving $100 to the American Heart Association or $100 to the American Cancer Society or your local Little League football or basketball or baseball programs, Those are all non-controversial kind of things that then will let you put on your website, and you should put on your website that you're a proud supporter of the American Heart Association or the American Cancer Society or whatever it is that you give to. Put that on your website. That conveys a message about you. I represent some folks and work with some folks and being very aggressive about how we use our website. Some of the folks run almost a post a day on a Facebook where they're honoring this driver for winning this award, or they're talking about the new equipment that they bought over here, or some other award that they may have won somewhere else. That's great. That's fabulous, and that's something that a jury sees and a jury would like if they in fact looked at that. But it doesn't have to be that extensive. It just needs to be something. And you should very aggressively think about using your website as a sword to convey and to project a very positive image about yourself. The converse of that is to make sure that folks in your organization understand how social media can kill us. I've represented a ton of folks over the years who think it's funny to put up things on social media about commercial motor vehicles, about how big and strong and fast they are, and how much damage they do if people get in front of them or if they cut them off. Those things are the kiss of death in lawsuits. So making sure that people that are in your organization understand, don't put up stupid things. As a matter of fact, the template that I usually encourage people to embrace is, if you're sitting in a witness chair in some courtroom somewhere and some smart aleck lawyer walks up to you with your most recent social media post, are you going to be okay with it? Me, and Karen's heard me say this many times, I'm a puppies and flowers and very low-key things on my website. I don't put up anything controversial for fear that somebody's going to see it, and it could be something that would be used against me. As many different courthouses as I appear at, I'm pretty sure that I get Googled relatively frequently. I don't want there to be anything out there that causes anybody to draw any negative inferences relative to me. Be aware of that and make sure your people are trained about that. Your reputation will go a long way in the defense of one of these lawsuits. Remember, the game from the bad guy's perspective is to make you seem dangerous and to make you seem like a corporate citizen that we don't want to have in our community. The things that you do to burnish your reputation before there's ever an accident are all very positive things and inure very dramatically to our benefit. Those are some things that you can do before an accident has occurred. What do you do when an accident occurred? Well, the first thing I'm going to tell you to do is you need to be prepared. You need to think about it. And you need to think about it from more than the standpoint of, oh, darn, I guess I'll just call our insurance carrier. Nothing wrong with calling your insurance carrier. That certainly needs to be in the tree of tasks that you need to get performed when an incident happened. But you need to think about it more globally than that. And you need to think about it substantially more globally than that to be prepared. I'm here to tell you that I represent trucking companies and folks that move things commercially, folks that have as many as 30,000 units running across the United States to folks who have 2 units running across Henrico County, which is where I live, and everything in between. The deal to keep yourself as safe and secure as you can is to understand one very simple principle. If you operate a commercial vehicles on the highways, with some of the idiots, with a lot of the idiots that we see out there otherwise operating vehicles on the highway, then it's only a matter of time before one of your vehicles gets involved in some kind of accident. I'm not saying it means that one of your drivers necessarily did something wrong, because God knows the world I live in. Most of the time, it's not our drivers doing something wrong. It's one of these texting, looking down at their Sirius XM with their laptop open while they're trying to feed a bottle to a 6-year-old kid in the back seat. That's usually what has caused the happening of a lot of the accidents where I'm otherwise engaged as a defense attorney. Having said that, it's going to happen to you, and you need to accept the fact that it's going to happen to you. If you do every single thing that you can do, it may not happen to you for a while, or you can do every single thing that you're supposed to do, and it may happen to you tomorrow. So contemplate and plan on the fact that at some point you're going to need an incident. There's going to be an incident. And when that incident happens, I'm going to tell you that one of the things that you need to do is have a lawyer somewhere that you can call. Somebody that you know is going to step in and step up and make sure that your company is protected to the fullest extent of the law. Not necessarily the company, the lawyer that the insurance company may send you, not necessarily some lawyer that may go to your court with your driver on a traffic charge. I mean a lawyer whose only job it is to make sure that your company is protected. There's a whole bunch of reasons for that, but the biggest reason I tell people is because if you talk to a lawyer in very close proximity to the time that an accident happened, then there's an attorney-client relationship that's established between you and that lawyer can be then charged with directing the investigation of whatever it is that happened. And it gives that lawyer an opportunity to make sure that the investigation is properly configured, that things that need to be looked at are looked at, things that don't need to be looked at aren't looked at, that we are getting to the witnesses that we need to get to as quickly as we can get to them to understand what their story is going to be, and that the appropriate evidence is otherwise preserved. Do not, and I can't say this in strong enough terms, do not rely entirely upon your insurer for that. I tell people that's a little bit like going to a doctor with major physical problems and then just expecting he's going to figure out all the problems himself without any input from you. You are the person at the time that an accident has happened that needs to drive the investigation. Be proactive. Be on top of what it is that's happening. Push the investigation. And having a lawyer who knows about commercial motor vehicles and commercial motor vehicle accidents is a huge, huge sword to put in your hand when it comes to fighting the bad guys on this. So have somebody that you can call, somebody that you know that knows something about commercial motor vehicle accidents, and somebody that you know will act in the best interest of your company. It's very, very important. Now I'm going to tell you some things that if you got your lawyer involved, your lawyer should be pushing this. If you've ignored that first piece of advice, then you need to push this. But in whatever event, it needs to be pushed. Again, I will underscore for this. Do not simply rely upon your insurer to make sure all this stuff happens. I promise you, on whatever day, God forbid, that accident occurs that I'm telling you is otherwise going to happen, that's going to be the biggest thing that happens in your company that day. When you call to report it to your insurer, you're going to get a claim number. You're just going to be another accident that happened for them that day, and you're going to get put into a triage where, depending on whatever else has happened among their insured that day, you'll get some attention sometime. It might be that day, it might be the next day, it might be next week. So you need to drive the narrative. But one of the biggest things I try to convey to folks is you want to be an educated consumer of your insurance services. And these are some of the things that you need to have on your short list of things that you are asking and questions that you're asking. And the first one is, are we going to the scene? Who are we sending to the scene of the accident? Are we going to send our lawyer? Or are we going to send an accident reconstruction expert? Are we going to send an independent adjuster? What are we doing to preserve the physical evidence? It matters. The physical evidence that you see in this photograph from an actual crash that I defended, that stuff means nothing to anybody and that's not otherwise expert and trained at looking at it. But it means something to me relative to how an accident happened. So it needs to be something that you are pushing as a narrative. We need to get to the scene. We need to get to the scene. You also need to make sure that you have somebody in your operation, you have somebody in your operation who's trained on how to deal with your drivers. And as a matter of fact, I'll take that one step further. What I do for the clients that I otherwise represent is I train their drivers. I go to their driver meetings. I talk to their drivers. Because to the extent that you're listening to this and you may not have a good sense of how litigation works, your drivers are one step even further removed from that. They probably haven't been through a civil lawsuit before where after happening of an accident, a commercial operator gets sued for millions of dollars and dragged into court, and then somebody tries to use the Reptile Theory on them. I mean, it's a daunting, confusing thing. That's not the business they're in. So you need to make sure your drivers are trained. They need to know how to deal, how to behave at the site of an accident. They need to know what to say. They need to know what not to say. I've got a little card that I hand out to drivers whenever I go to these drivers meetings. And anybody that wants one, reach out, send me an email, touch base with Karen. She'll send you over to me. I'll send you the card. You can use it for your drivers, or I'm happy to talk to your drivers. But they need to know how to react. They need to understand that they are our first boots on the ground after an accident has happened, even though they are the people who otherwise were involved with it. They're there to see what's there to be seen. They see the other person who's involved in the accident. That same person who's getting out of their car, coming back and yelling at our driver and throwing his arms up and using all kind of vulgarity and profanity, that's probably the same guy they're going to roll into my office a couple years from now in a wheelchair and a neck brace and say he was horrifically injured in the accident. So having your driver understand the simple things that they can do at the scene to help us start the process of defending these cases is important. They need to know, for example, take photographs of all damage to either of the vehicles that was involved, all damage. Anything that may depict damage to our vehicle, anything that may depict damage to the other vehicle. Take photographs of anything that appears to be physical evidence that's in the road, pieces of debris, pieces of the vehicles that may be lining the road. If there are skid marks, yaw marks, anything like that, take pictures of that. By all means, take pictures of the other driver. And always tell my drivers, make sure that they get out of their vehicle, they walk up to the other car, and they ask the other driver how they're doing. I make sure my drivers know that there's a pretty good chance that whatever they say could be recorded. So don't walk up and say something stupid. When they do walk up, all they're going to want to say is, "Are you okay?" But the real reason they want to walk up and look at the other vehicle is to see what there is to be seen. Are there things in the vehicle that may have raised suspicion about what the other driver was doing at the time the accident happened? Is there a bag of weed there? Is there a bottle of booze there? Are people scurrying to get dressed? Whatever it is, make sure that the driver knows how to do that and knows, for goodness sakes, never to apologize for the accident. There needs to be somebody on your end who knows how to deal with the driver. That when the driver calls in, when our driver calls in and reports he's been in an accident, there needs to be somebody in our shop who's trained on how to interface with our driver, knows how to talk to our driver, knows how to calm him down, knows how to go over the list of things to do and the things not to do at the side of the accident. Those are all very, very important things that you can do now, you can anticipate now, so that you're ready for now in the event that an incident otherwise happens. The other thing I would tell you is you need to make sure, you need to know this now, you need to know what type of electronic recording devices there are on any of your commercial vehicles. Almost all commercial vehicles manufactured from as long as 20 years ago have some type of electronic control module or electronic control device on them that record a variety of data. And the newer trucks have several electronic recording devices on them. They include not just airbag control device, but several electronic control modules on the engines themselves. You need to know what's on your equipment, and you need to know what those control modules are capable of recording. And most importantly, you need to know what the overwrite protocols are for those control modules. That is, under what circumstances will the data that's recorded on those control modules be overwritten? Sometimes data is overwritten when a vehicle's turned on. Sometimes data is overwritten when a vehicle's moved. Sometimes data is overwritten when a vehicle's moved at a speed greater than, say, 10 miles an hour. Whatever it is, you need to know, because almost always after the happening of an accident, we're going to want that data. We're going to want the data that demonstrates how our truck was being operated at the time the accident happened. Those are all important things for you to know now, and for things for you to know at the time of an accident to make sure that you're asking about. That is the data. We also need to make sure that our employees are trained on how to deal with these guys. There is probably no bigger advocate for these guys than you ever going to find. I routinely tell folks my experience with uniformed police officers has been uniformly, no pun intended, excellent. I've never had any dealings with any of these guys that had been anything other than excellent, unless I was doing something I shouldn't have been doing, and just finished doing something I shouldn't have been doing, or was planning on doing something I shouldn't have been doing. They're good guys. They've got an impossible job. But your drivers, if they've been involved in an accident, need to know how to interface with these guys. And it starts with some simple concepts like training your drivers to be polite. Being a smart aleck to one of these guys is never a winning recipe for anything. But perhaps the more important thing is making sure that your drivers understand that they get involved in an accident and one of these guys wants to talk to them about what happened, that what actually is occurring is in the nature of a criminal investigation. They are asking questions incidental to the issuance of the possible issuance of a criminal citation, that is a traffic citation, and that your drivers understand that they do not have to talk to the police officers at the scene. They can be polite, but if there's any question in their mind about what it is that happened, the chances are substantial that they're not going to talk an officer out of a ticket that's already intent on giving them one. And if there's any question in their mind that they may have done something wrong, instead of just starting to blab at the scene about what they think may have happened, then the better thing for you drivers to be trained to do is to say to the officer, "Officer, I'd be glad to talk to you about this. Can we get together tomorrow morning at 9 o'clock after I have an opportunity to get my thoughts together?" And I tell people to do that routinely. I take calls from drivers at the side of the road at the scene of an accident. I probably do get 50 of them a year where I talk to drivers and just tell them, just don't talk to police. We'll do it tomorrow. Particularly in their cases where there's any kind of electronic data that we can then get off of a vehicle, a commercial vehicle, and look at any GPS data, any ECM data, any type of data that would tell us something about speed and brake application. I always like to look at that and then tell the driver what the data shows before a driver talks to a police officer. There's nothing that will get us killed faster in one of these cases than one of our drivers being asked by a police officer and thinking that he's cooperating, saying at the side of an accident and asked how fast he was going. I was doing 45, and then we pulled the GPS data or the ECM data, and it shows that he was doing 67. If that happens, he's lied to the police officer, he's killed his credibility, and he's killed us in front of a jury. So again, making sure your drivers know how to react and how to interact with these guys is a big deal. It's also important to understand that if there's a citation that's issued by one of those guys, in almost every state where I practice, a citation that's issued is not in and of itself admissible in a subsequent civil claim for damages related to personal injuries unless you plead guilty. So while there may be great incentive for a driver to decide, I'm not going to court to fight this ticket, I'm going to go ahead and just pay it, send it in. If they do that, then they have pled guilty to the charge, and that guilty plea will be admissible against us in a subsequent civil suit. So again, $300-$400, whatever you got to pay to get a lawyer to go with your driver to make sure that that guilty plea does not get entered is money very well spent. Other things that you want to make sure that you're driving at the scene of an incident, that you're asking about, that you're looking for. Excuse me again. Were there any traffic cameras there? Any surrounding videos? Anything like that? Who were the witnesses? Who saw what? Making sure, again, you're driving the identifying of those people and making sure that there's somebody who's tasked up with getting to those people and having them talk to them. I don't always, and this next slide is one that I don't always mean to suggest that there's necessarily tension between a company and its insurer, because there's sometimes, very oftentimes, there are not. But there can very oftentimes be substantial tension between you and your insurer. Insurance companies, particularly side that deals with claims, are set up for purposes of doing initial and as cost-effective in their mind investigation of claims and getting the claims resolved. They don't always have any interest in trying claims or trying lawsuits to verdict, because candidly, I don't think they like what they see in front of juries a great deal of the time. You need to be aggressive, though, in the management of your claim, particularly with your insurer. You need to make sure you're asking for an evaluation of the claim as soon as one is reasonably available. You need to make sure that you've made clear your desire to be involved in the claim process. If a lawsuit's filed, you want to make sure that you're kept apprised of what's going on. Do not assume that no news is good news. As a matter of fact, no news is almost always bad news in the world in which we live in relative to lawsuits. So set a reminder once a claim is filed or once a lawsuit is filed to ask for some kind of status update at least every 3 months or so. So now we have had, I've told you things that you ought to make sure that you've done before an incident happens. I've told you things about an incident's happened, and now I'll talk to you just a little bit about the things after an incident has happened to make sure that we're as good as we can possibly be. You heard me mention the citation thing just a moment ago. Under note, this is one of those never, not ever, ever things. That is, do not ever, ever, ever let your driver simply plead guilty to a citation. Doing so is something that almost 100% of the time will kill us. It is much better off to contest each and every citation that goes against us. It's also critical. One of the things that feeds very clearly into the reptile narrative is a failure to do any type of drug testing. You need to know what the deal is about when a driver should be drug tested subsequent to an accident, and you need to do everything to make sure that that happens after an incident has occurred. Failing to conduct a drug test will get us killed. Make sure, as I said, you also have an understanding of the types of data. There's going to be certain information that you're going to need to very proactively retain after an accident has occurred. I've got a checklist for anybody who's interested. Again, reach out to me directly or reach to Karen, and I'll send the checklist to you. It gives you the kind of outline of the things that you're going to want on the vehicle, the year, make, model of the vehicle, the VIN number of the vehicle, whether it was loaded, unloaded, if it was loaded, approximate weight, when was last service, what the repair, maintenance, and inspection records look like, your driver's qualifications file, all those kind of things. You also heard me say making sure that you're aggressively driving the narrative and driving the investigation. One of the things that you're going to want to make sure that you are very aggressively driving is asking your insurer, where is the other vehicle? Where is it? And are we going to do what we need to do to inspect it? The things that you can find in other vehicles, photo from a case that I actually had, is pretty helpful. But it's the kind of thing that you want to know what's in that other vehicle. You want to know what kind of shape the vehicle was in. We want to get the vehicle and see what did have a valid state inspection. Is there anything in the vehicle that would suggest that there was some kind of distraction for the other operator at or around the time the accident occurred? You may well get a letter after an accident happens from one of the TV lawyers. You have an accident, you tell your insurer and or talk to your lawyer, and then it goes radio silent for 2, 3, 4 months. And then one day you go to the mailbox and you get a letter from Joe Q Plaintiff Law Firm that tells you that there are 83 categories of information that they want you to retain relative to the happening of this accident. Don't ignore that. Don't throw it in the trash can. Make sure that that letter is conveyed immediately to your insurer and to your lawyer. That letter requires a very specific response, and failure to respond is particularly damning to us. Understand that the bad guys send those letters hoping that you will ignore them, because they really don't care about whether you retain the information. They want you to ignore the letter and not retain the information, because that then allows them to say that the information, had it been retained, would have shown that you did something wrong. So again, don't just ignore those things. Also encourage people that from the moment you have the name, and I don't rely on anybody else to do this, I would encourage you not to rely on anybody else to do this. From the moment you have the name of the other individual involved in any crash with one of your vehicles, get on social media, get on the internet, and see what you can find out about them. Again, I would do that sooner rather than later. I would see what's on Facebook. I would see what's on Facebook 2 days after the accident happened. You have no idea the number of people that we see who claim they were involved in substantial rear-end collisions. For example, on a Wednesday, they'll go to their daughter's wedding on Saturday, post video of them dancing at the reception Saturday night, and then claim 2 weeks later that they can't get out of bed. So being aggressive and proactive about that is something that you can do that will help you and your company in defense of that. There's a whole theory out there now that the defense bar has come up with, which is the mongoose theory. It's meant to kind of controvert the reptile theory. I've read it. It's perfectly fine. The bottom line on all of it is be aggressive. Fight to win. Understand that the game that we're playing involves somebody who is coming after the resources of your company and want the resources of your company. If you are passive and you allow folks to aggressively take advantage of you, then that's exactly what it is they're going to do. They're already going to take advantage of the fact that you're not in the lawsuit business. You're in the logging business, and your business is to fell trees and to sell trees and to do things relative to processing of wood. And that's the business that you're in. You're not in the business of filing lawsuits and defending lawsuits, and they're going to take advantage of that. But you need to be aggressive. You need to be aggressive about what it is that you're doing now to get your company in order to face potential claims. You need to be aggressive and educated about what you're supposed to do at the time an accident happens to make sure you're maximizing your defense. And you need to know what to do after an accident happens to make sure you're maximizing your defense. Because failure to do those things is something that feeds, again, directly into the narrative that the bad guys want to promulgate and makes it easy for them to hit us and to hit us hard in the places where we do business. So with that, I will wrap up, and Karen, I will turn it back over to you. You're on mute, Karen.
Thank you so much, Stephen. That was wonderful, as always, always very informative. And I am going to give the folks a few minutes if they would like to ask you any questions about your presentation, about those liability topics. Guys, yeah, he is a lawyer and he is going to answer your questions for free right now if you come up with them in the next 25 minutes. So by all means, again, we've got the either the 2 talk bubbles or the 1 talk bubble. Either one, you can type your question in, or the raise hand icon if you'd like to ask your question out loud. And I'm going to be monitoring the chat and the Q&A. I'm looking at the attendee list, so I'll be able to see if you raise your hand. I know not everybody here has a trucking component to their business. You may be contracting truckers or whatever, but still a really good topic. So
Karen, let me mention just a couple things too. I should have said this at the beginning. I know this is available on record and people can get. I'm also happy to share the entirety of the presentation with anybody that wants it. And you should feel free to disseminate it or tell people to reach out to me directly. I'll be happy to give it to them. I mentioned the checklist, the post-accident checklist that's available. I'm happy to share that with anybody. I've also got the driver cards that I'm happy to share with anybody. And I will, at the risk of sounding more like a Baptist preacher than probably I want to, man, we are, Karen's heard me say this before, but we are kind of in this thing together. And if we don't take the steps to try to combat what I'm seeing is occurring, the extent to which I've seen this change over 30 some years of practice of law is in fact remarkable. We've gone from a swing from people thinking that people that run businesses are good guys and job creators to, in a lot of places, they've become kind of the enemy in a lot of the places where I try cases. So being aggressive to put the best face on your company and anticipating that something bad happening, 2 things that I cannot underscore hardly enough.
Yeah, I spent a lot of time on I-81 on Sunday, many more hours than I had anticipated spending on I-81 on Sunday. And there were a lot of accidents, and even on a Sunday there were a lot of trucks out there, and a lot of people. I don't know if it was the tryptophan and the turkey, or if it was the fact that Thanksgiving is one of the biggest alcohol sale holidays, but a lot of accidents, a lot of stuff to be prepared for. I picked up one of your checklists at the last thing we had in person, and I think it's probably in my workbook bag. It needs to probably go in my glove box, because even if you're not driving a commercial vehicle, it's still relevant,
Sure.
So
yeah, it's a my youngest son goes to JMU, so I'm on 81 frequently, and I'm a commercial motor vehicle advocate, so I'm always watching, and I would say a solid 80 to 85% of the time, it's not the truck, it's the guy in the Kia that cuts him off, that causes the truck to have to get all over his brakes. It's, or the idiot who tries to beat one at an on-ramp. It's just the stuff that I see people do around those vehicles, not understanding the operating characteristics of them, that leads to leads to the great majority of the problems.
Yeah, I drive a Kia. I'm laughing.
The other thing it does lead to problems, and that's why I'm such a big advocate for telling folks to train your operators is certainly there are guys out there that do stupid things in commercial motor vehicles, and they're the ones that give us all a bad name. So the more we can do to get ahead of that, the better we are.
Yeah. I was laughing because I drive a Kia, but I have been I've sat through enough of your presentations and also presentations from the insurance carriers, from FMIC. They've got a trucking thing that they're doing now, and Jason Kreiser with Gaines and Kreiser always does a little trucking thing. So I've seen a lot of it now, and I feel like I had pretty good respect for the big trucks before, but I got even more respect for them now, and I'm not cutting them off, And if you're behind me and you think I'm not passing them fast enough, and you're going to cut them off so that you can go around me on the right, like that's on you, but I'm not cutting them off.
If the average person sat in the cab of a truck, they'd understand. They'd understand just there are definite limitations on what you can do when you're in there and what you can see. And when I watch the idiots pass them on the right, it's just it's not a good thing.
Yeah, yeah. So I'm really surprised we haven't seen any questions yet. Usually we get a lot of questions, for you, because it's a really important topic and all that. But I guess we have, maybe mostly in woods guys today. So not a lot of that. I know when we were at I guess at the Tractor Museum for the legal and safety training. I don't think it was you. I think it was somebody else from your company mentioned, like when you are working with maybe contract truck drivers, that you need to be careful to make sure that that they are contractors and that they don't come across as employees. They were talking about making sure that they are free to decline your requests, that they are free to take work from other people, and some of those other things to make sure that they're not your responsibility.
Yeah, so I can mention just a couple things about that. One, relative to the topic that I just presented, which is a lot of folks try to avoid liability with commercial vehicles by hiring, quote, contractors or owner operators to operate for them. And a lot of people operate under the very incorrect assumption that if they've hired an owner operator, or they hired, you've got your company and you hire another smaller company or another company to haul for you, that you somehow offboarded any potential liability relative to that. That's not true. In Virginia, particularly, and as in most of the states that we're here talking about, you can still get sued if you didn't exercise reasonable care relative to whoever you hired as the owner operator. So you need to make sure, it's almost like hiring an employee. If you're going to hire an owner operator to carry your loads or to do the work for you, you better make sure that you've exercised a reasonable amount of care, that you've picked somebody who's suitable for doing that. Because if you go out here and you hire somebody who's not suitable for doing that, you're just as liable as you would be if they otherwise were your employees. And then there's the other issue that I think my partner was talking about during the meeting, which is the whole idea of using contractors actually on site and on the job, and then having independent contractors who come and do that. That is an issue that's become really hot in a lot of states. California's got a big deal going on with it now, but it's also come under a great deal of scrutiny here in Virginia, because one of the consequences of doing that, obviously, is that you don't pay the same type of employment taxes that you would pay if you characterize them as independent contractors. That gets scrutinized very closely by the Virginia Department of Trade and Taxation. We get involved with a lot of audits with folks relative to that issue, where the Department of Taxation essentially concludes, you might call them contractors, but they're not. We're going to call them employees, and you owe us a whole bunch of employment tax relative to those guys. So there's some definite rules and things that you need to understand if you're going to go down that direction.
Yeah, appreciate that. I know, a lot of our audience are, a lot of them are owner operators in a sense of their, logging equipment and their logging business. It might be them and their brother, or them and their son, and they're used to doing everything on their own. So it's good to know when it really behooves you to get a lawyer, or, an accountant, or, some of those other specialists, and not to try to do everything on your own.
Agreed.
We still don't have any questions. I thought of something else, but I forgot it. So, yeah, well, I think that probably if people were going to ask questions, we would be seeing them in there by now. So if we don't have any, we can end a few minutes early. I do appreciate your time. And
sure.
I appreciate all of my attendees for being here. We will make sure that you get your credits. So the folks at Maryland will send those to the folks at West Virginia, who send them to me and the folks in Ohio, and we'll make sure you all get your credits. You should get a certificate shortly after I end the webinar. I think, does that happen automatically? Or is that something Ben does by hand? I think Ben might do it, but you'll get that, and we'll make sure you get credit for that. And Again, I really appreciate Stephen's time. I appreciate all of you, and be safe out there. Be well.
Thanks, Karen. I know.
Thank you.